Look at
it. He does not want redemption, Your Honor. He wants to kill.
There's a lady bleeding terribly. Somebody fuck her and she's bleeding so badly.
My mind are consumed with despair, pain, sadness, grief.
Tempers flared as families attempted to leave, leading to an outburst that forced the judge to intervene. The two sides threatened each other, yelling and blaming one another for their losses. Words filled with anguish and anger echoed through the courtroom as Cordon Walker was handcuffed and escorted out.
Shut up! This is all out of pain! Everybody hear her! No!
The outburst sparked fury from both families, emotionally reflecting the deep pain and betrayal felt by Lully's Keemulin's mother.
I loved you at one time. I accepted you into my family. You promised me that you can be good to my daughter. You failed me. You failed as a man, a father, and a son.
With a bitter tone, Fabi recalled the trust she had placed in 23-year-old Cordon, which has now been shattered and replaced by an overwhelming sense of loss. Lully spent the day celebrating her 23rd birthday on August 26, 2020, which would be the last time her family saw her alive. The celebration took a horrific turn when witnesses reported waking up to screams and seeing the young mother lying in a bush, while Cordon allegedly beat her and then ran her over.
It sucks. It hurts to know that we waited 3 years to not even get what we really were hoping for, which was an answer as to why.
The courtroom is silent, the weight of their grief intense in the air. Everywhere they look, reminders of happier times surround them. As they gaze forward, they feel a void, longing for the past and aching for a future that will never be.
For my niece, it's hard to see because she comes up and we only got pictures. She says, I miss my mom.
Lully's family has been waiting for this day for years to confront Cordon. He requested to face them.
I truly, sincerely apologize. And how you guys feel is validated. You feel me? So I just apologize. And no love is lost on my side. I love all you guys, and you guys deserve this moment.
In a rare moment of humility, Cordon acknowledged the irreparable harm he had caused both families. His mother spoke about her relationship with Cordon's father, describing it as a house of horrors, and claimed that their tumultuous relationship significantly impacted his development and contributed to his violent outbursts.
And Cordon will have to live out the rest of his days knowing that it was at his hands the woman he will forever love lost her life.
All eyes were on Judge Avril Rothrock, who bore the responsibility of sentencing Cordon.
He was strangely cold, callous, and unmoved immediately after he ran over Ms. Keemulin. I have determined to impose a sentence on count 2 felony murder of 17 years or 204 months.
With the sentencing behind them, both families can now begin the process of healing.
May the Keemulin and Walker families one day find peace.
The judge stated that this is one of the most egregious cases of domestic violence the court has ever seen, which weighed heavily into the decision made. Cordon is facing 204 months in prison for the felony murder of Lully's Keemulin and an additional 5 months for unlawful possession of a firearm, to be served concurrently. Upon release, he will also be required to attend battery courses and therapy, and he will not be allowed to drink as part of a 3-year community custody sentence. A husband tearfully confronted his best man in court, revealing that the best man at his wedding had murdered his bride.
To keep the outside world, to keep evil out, right? But what happens when evil has a key?
Since high school, Nation Hawn had been best friends with John Broyhill. When Hawn married Jamie Kirk, Broyhill stood by his side as the best man. The three even took vacations together, but tragedy struck when Broyhill stabbed Jamie to death in her home.
There's a lady bleeding terribly. Somebody fuck her and she's bleeding so badly.
Jurors in Raleigh, North Carolina, reached a verdict in just 90 minutes during his murder trial.
We, the jury, find the defendant guilty of first-degree murder.
Jamie's loved ones were overwhelmed with emotion in the courtroom. While delivering his victim impact statement, the grieving husband confronted his best man face to face.
We've learned so much about the evil that exists in this world, evil that is represented today with this murder in front of us.
Jamie's parents expressed their profound grief during the proceedings.
When we think about how scared she must have been and how painful the end of her life was, we almost lose our minds.
John, you gave Jamie a death sentence. You gave all the rest of us a life sentence.
Jamie was a well-liked political strategist for former Congressman Brad Miller. Prosecutors stated that Broyhill stabbed her when she confronted him with evidence that he had embezzled over $40,000 in campaign funds.
Tell me what your thoughts were on the sentencing, which was life in jail without the possibility of parole.
Oh, I think that's certainly appropriate. I don't want Jonathan Broyhill to be outside of prison again for the rest of his life.
John Broyhill was sentenced to life in prison without the possibility of parole for the murder of Jamie Kirk. The man who killed his sister's ex-boyfriend by stabbing him and then setting him on fire will spend the rest of his life in prison. Adonis Betances chose not to appear in court for his sentencing, but that did not prevent the victim's loved ones from delivering heartfelt victim impact statements. The judge emphasized the depravity involved in this case, describing it as a particularly vicious murder. The medical examiner determined that had the victim not suffered burns covering 90% of his body, he would have died from the stab wounds that perforated his lungs. This led to Adonis Betances being charged with and convicted of first-degree murder.
He was never a danger to Motherly.
A mother so overcome with grief was unable to continue addressing the court as she described the pain of losing her son, Winston Ortiz. A grief counselor stepped in to finish reading the victim impact statement on her behalf.
The defendant caused so much hurt and pain to my family for what he has done and has shown no remorse.
The defendant, Adonis Betances, refused to enter the courtroom for his sentencing. Betances was convicted of the particularly gruesome and heinous murder committed in August 2020, where he repeatedly stabbed Ortiz. He was angry that the victim had been in a relationship with his sister. For his part, Ortiz was active in his church and had previously survived a brain aneurysm.
Winston was an amazing person. Throughout his life, he had worked hard and he had dedicated his time for others as we had raised him.
The trial was especially gut-wrenching for the family, who watched police body cam footage in which the dying teen identified his attacker and then prayed for forgiveness. The family urged the judge to impose the maximum sentence of life without the possibility of parole.
He does not want redemption, Your Honor. He wants to kill. If he is released from prison, he will do this again, or worse. I fear for my life. I fear for my little brother's life. I fear for the rest of my family. And no one will be safe with him walking free.
Betances' lawyer, noting that he had never been arrested and had no criminal record, asked the judge for the minimum sentence of 20 years to life with the possibility of parole. However, the judge rejected this request, stating that Betances had shown no remorse and, in fact, still maintains his innocence to this day. The mother is discussing her son, whom she brutally murdered.
My heart and my mind are consumed with despair, pain, sadness, grief, unceasing anguish, and extreme remorse.
Joanne Cunningham pleaded guilty to the murder of little AJ Freund. His voice from beyond was pivotal evidence, as a recording played in court revealed him saying he wanted to see her hurt.
But why do you want them to hurt me? Why? So I don't ever see you again.
There was also a heartbreaking moment.
I just don't want a family.
Cunningham garnered national attention last year when she and AJ's father reported the child missing.
What is your message to those people who think you're withholding information?
I have no control over what people think. I just want my son to come home, okay?
A K-9 unit detected AJ's scent in the trunk of his parents' car, and when police found his body in a shallow grave, both parents were charged with murder. AJ's father has pleaded not guilty and is awaiting trial. Prosecutors allege that on the day AJ died, he was forced to endure a 20-minute cold shower and was beaten as punishment.
Through my negligence, my weaknesses, and failures, it created a host of problems for me.
Her words seemed hollow as she read from a prepared statement. Prosecutors claimed that her tears were selfish. She was sentenced to 35 years in prison with no chance of parole. Deshaun Boylan was removed from the courtroom after yelling at witness Everett Glover. At the end of the preliminary examination, Boylan abruptly stood up and exchanged words with the victim's family. This incident occurred while Boylan was present for his preliminary hearing.
However, he could be released to the department. Can we approach one section? No, I'm happy to shut up.
Bro, stop looking at me, bro.
Bro,
I'm not playing. Look at me. Hey.
Oh, wow.
Quiet. Have fun in prison, bro.
That's no good, man.
Hey.
Everett Glover, 25, was charged as a second-time habitual offender with lying to a police officer in a violent crime investigation. A large crowd gathered outside the courthouse, where lawyers for Karen Reed, the woman accused of killing her police officer boyfriend, formally requested that the judge remove herself from the case. Reed is facing charges in connection with Officer John O'Keefe's death. The crowd cheered as Karen Reed left the court, but this time, she did not address the accusations against her regarding the death of her Boston police officer boyfriend, John O'Keefe. Instead, her father spoke on her behalf.
We're just gratified and we're so thankful for so many people in support of our daughter and our family.
O'Keefe's body was found in a snowbank outside the Canton home of another police officer who was hosting a gathering. Prosecutors allege that Reed ran over O'Keefe with her SUV after dropping him off and leaving him there, but her attorneys argue that she was framed, a theory that has captivated the public's attention. A crowd gathered hours before the hearing to show their support. Inside the courtroom, the prosecutor requested that the defense team refrain from speaking to the media.
The hyperbole or the language that's been used on the steps of this courthouse in reference to the Commonwealth having its foot on the defendant's throat.
The defense lashed out in response to that request.
How dare the prosecution try to prohibit defense counsel from doing our jobs? How dare they ask this court to take away our First Amendment right to free speech?
This occurred after defense attorneys accused the judge of showing bias against them, requesting that she recuse herself from the case due to an internet post claiming she allegedly knows potential prosecution witnesses, a claim she strongly denied.
I want to make it very clear that I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself from a case.
The judge did not withdraw from the case. She stated that she would consider the request and return to court. Some dramatic words were exchanged in court as a judge sentenced an SKC man to life behind bars for murdering his mother and her partner. The stern sentencing occurred in Sked County Court and included a surprisingly heated exchange between Judge Matthew Cusey and the defendant. The judge angrily admonished Nicholas Fiebka, telling him, "When it comes to sentencing, there's no suspense. You know what's coming." And then the sentence was handed down.
How was you talking nonsense during your interviews?
If 21-year-old Nicholas Fiebka was seeking mercy during his double murder sentencing in Sked County Court, he was looking in the wrong place.
You murdered him for the most basic of reasons. Hatred, anger. That's what you think? That's what I know. Ain't no mystery to me why you did it.
Nicholas Fiebka received a life sentence without the possibility of parole, despite an impassioned plea from his defense attorney, Mark Sacco.
It is absolutely a mitigating factor that Mr. Fiebka suffers from serious mental health issues. That probably if he didn't have those issues, he wouldn't have done this.
When allowed to speak, Fibka did address the court.
I just want to say I'm a servant of God, and they can paint whatever picture they want, but God knows who I really am, and my heart, and how pure it is. So.
Assistant District Attorney Christina Tranti-Pelham labeled Fibka as one of the most dangerous defendants she has ever prosecuted.
What we've learned about Nick Fibka in this case, his history, the manner in which he committed this crime, the brutal deaths that these people suffered, and his overall feeling of, I don't feel bad for what I did. Those are the words of someone who should never, ever get out of prison.
Tranti-Pelham stated that Fibka transformed from a child with behavioral issues into a destructive, violent man, asserting that when he gunned down his mother, Alicia Wadsworth, and her longtime boyfriend, William Horwell, in their Princeton home in 2022, it represented an escalation and continuation of Fibka's long history of threatening behavior.
Obviously, we feel that this was absolutely the right sentence.
In the months leading up to the murders, a family court judge had granted Alicia Wadsworth a complete stay-away order of protection against her son, requiring him to surrender his firearms. However, authorities reported that Fibka managed to purchase another AK-47 by lying on the application. At the scene of the double murder, at least 44 bullets were fired. A Fulton County judge has again denied bond for an Uber driver accused of shooting and killing one of his passengers while injuring another in a manslaughter case. Kevin Fulton's family told the court that his death had been devastating and had taken so much from them. They referred to him as Vino, noting that he was a recent graduate of Morehouse College with a bright future ahead.
To grant the defendant bail would cause the family an extremely unhealthy and perpetual high degree of anxiety.
Several members of Kevin Fulton's family passionately urged a judge not to grant bond to former Uber driver Nigel Nahmart. Prosecutors alleged that the 36-year-old was driving when Fulton and two friends requested him to change the genre of music on the radio. According to investigators, the exchange escalated when Nahmart pulled over, dialed 911, and asked the three passengers to exit his vehicle. The defense provided an explanation regarding the driver's actions.
The deceased person got out of the vehicle. Another person got out of the vehicle. They went to the front, to the driver's side of my client. One of the individuals spat in the face of my client, and the other individual said, well, we're going to kill you.
Prosecutors contended that the defense's account is not accurate, asserting that there is video footage of the shooting from the Chevron gas station, showing that the young father was running away when he was shot in the back. The defense argued that Nahmart fired in self-defense and noted that he has never been arrested in the past. The suspect's mother also pleaded with the court to release her son on bond.
He's a loving, caring person. He loves kids. He loves everyone. He loves to work.
However, Kevin's mother told the judge that the suspect's mother will never understand the pain she feels.
She still has her son. I do not. A parent should not have to bury a child. In Your Honor, this is not how it's supposed to be. And forgive me for sounding angry because I am.
The judge denied bond in this emotionally charged case, stating that there will be no bond for now. Prosecutors indicated that they will re-indict the case, so the defendant will face not only felony manslaughter charges, but also murder charges. No bail has been granted for a man charged in connection with the death of a mother from Lawrence. She was reported missing, and sadly, hours later, her body was discovered in Haverhill. Disturbing details about the case emerged in court. The victim was described as a personable and friendly mother of two, and now her next-door neighbor is charged in connection with her death. 35-year-old Christian Montero was arraigned in Lawrence District Court regarding the case of Carol Floss-Burgo, a 37-year-old mother of two who was found dead in a Haverhill park after being missing. The two lived in the same apartment building. A prosecutor revealed that a hallway surveillance camera recorded the victim's final moments as she entered the suspect's apartment.
When officers observed Ms. Burgos walking into the apartment, she appeared to be texting, making the sign of a cross when she entered.
Authorities state that the victim was never seen leaving the apartment. However, the same hallway surveillance camera recorded the suspect.
They did, however, observe about 2 hours later the defendant, Christian Montero, to be leaving the apartment complex with a wagon, a beach cart that appeared to be filled with clothes.
At the time Montero was seen pulling a wagon filled with clothes, investigators noted that the victim's cell phone was active and pinged in the Haverhill area. A Massachusetts State Police canine later discovered Carol Flasbergo buried beneath a pile of leaves in a Haverhill park. Christian Montero is charged with providing false information to investigators. They allege he lied about visiting a Lawrence barber shop after leaving the apartment, but city surveillance cameras indicate that he was never there.
I'm in shock. I'm in shock. I'm like, what was the reason? So we don't know yet.
It's touched everybody. You know, she's a mother. So everybody was hoping to include the police department. They wanted to bring this to a happy ending. But at the very minimum, we find ourselves being able to bring them justice.
The suspect is currently charged only with misleading investigators, but that could change. The district attorney mentioned last night that the charge could be upgraded to murder. The suspect has been ordered held without bail and is scheduled to return to court for a dangerousness hearing. A jury has recommended the death sentence for convicted killer Donald Smith, who murdered Cherish Periwinkle in Jacksonville 5 years ago.
Reviewing the aggravating factors that we unanimously found to be proven beyond a reasonable doubt in Section A above, we, the jury, also unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death, and they have marked yes.
Donald Smith was sentenced to death for the murder of Cherish Periwinkle. Philip Johnson Jr.'s mother, Jean Henderson, delivered her victim impact statement during the sentencing of two men, Dreshawn Glaspie, 21, and Jamario Dooley, 20. Both were convicted of felony murder in connection with her son's death.
On December 29th, 2014, I got a call that my son was dead. In my heart, I knew you did it, Trisha. Because on September 25th, you was over there. Laughing and giggling. I told Philip you were so grimy to keep you away from the house. I knew y'all all grew up together. Me and your mom have a 20-year friendship. He told Mom, I know how he is, but that's my friend. And then you had the audacity to call the house saying you was up about the situation. You sent your condolence. But all along, I already knew that you did it, and I told that you did it. You got the audacity to sit here and ask for forgiveness. It'd be a cold day in hell before I forgive either one of y'all. No remorse at all. Y'all in jail, taking pictures. Like it's funny. I lost my son. Your mom can have 15-minute calls. Y'all can have 8-hour visits. I can't do none of that. I can't. You gonna kill my son because you owe him. You should have just paid him. He didn't confront you. Me. I lost my son for something. He didn't even share the weed with you. Y'all didn't get the money, so what was the point? Philip lost his life. That's all I gotta say. I hope y'all rot in hell.
Thank you.
Glaspie and Dooley were convicted of felony murder on April 23rd. The jury also found the men guilty of conspiracy to commit assault with intent to rob while armed, as well as assault with intent to rob while armed. This is Kirsten Lobato, who served 16 years in prison for a murder she did not commit. At just 18 years old, she was charged with the brutal murder of a homeless man in Las Vegas. Initially convicted of first-degree murder, she was later retried and found guilty of the lesser charge of voluntary manslaughter, receiving a sentence of 13 to 45 years. After spending 16 years behind bars, a new hearing was held with evidence confirming that the victim's death occurred while Lobato was 3 hours away with her family, proving that she could not have committed the crime. Now, Lobato is outside for the first time as a free woman.
I feel overwhelmed, I feel excited, I feel grateful, I'm so happy.
Lobato has filed a lawsuit against the Las Vegas Police Department.
So where to now?
Okay, well we got more people coming too.
Her compensation claim is currently ongoing. In a tragic and life-changing confrontation, two young women saw their worlds altered forever in a single moment. Halia Culbertson and her 20-year-old friend, Brianna Barozzini, were involved in a physical altercation that ended in a devastating loss. During the fight, Culbertson tragically lost her life, and Barozzini later confessed to being responsible for her death. The two women had been close friends before the incident, making the tragedy even more painful for their families. Culbertson's loved ones fondly recall her vibrant personality and contagious smile, remembering her as a young woman just beginning to embrace the possibilities of her future. Her mother, Haley Culbertson, shared the deep pain of her loss, saying, "The pain of losing a child is beyond words. It's a constant, unrelenting ache in my heart, and a knot in my stomach that never goes away." Barozzini was charged with involuntary manslaughter and eventually pleaded guilty, acknowledging her role in the incident. Her legal team claimed she acted in self-defense, but the heartbreaking reality left both families struggling to process the outcome. During court proceedings, her attorney, Robert F. Krappinch, highlighted her regret, stating that Barozzini showed genuine remorse and an understanding of the impact her actions have had. In court, Halia's grandmother, Catherine Langley, mourned the loss of her granddaughter's untapped potential. She expressed her grief, saying she was just starting to discover what she could bring to this world. Her family never got the chance to see where her passions and zest for life might have led her. Family friend Mackenzie Adrian reflected on the loss, saying, "When Halia left, it felt like a piece, or even all, of my soul left with her."
Halia is gone. Well, so is Haley and Kaylin, lost in an abyss of depression and desperation, anger, frustration, and confusion. Haley and Kaylin began serving their sentence on 27 March 2023, as have the rest of Halia's loved ones. We haven't gotten over a year reprieve. We don't get a maximum 3-year sentence. Our sentence is a lifelong heartbreak.
How I would describe the Barazzinis, I'd say I can't trust them as far as I can throw them. I wish this wasn't what I was doing, reading a statement. I'd rather be sitting there every day through court and talking on trial a million times and writing and saying my statement to you. I wish I was reading a speech at her wedding, seeing her raise kids, get her nursing degree she always wanted, or even living and talking to her when we get old in a nursing home. After listening to me and hearing my statement, I hope you understand who Leah was. She was an absolutely beautiful, that soul that she had, always wanted to help. Her heart was so big, she could give it to anyone. I miss her every day. She was my alarm in the morning, my personal therapist when I needed someone to talk to, and my little sister in my eyes. I could tell you about Leah for hours, but I couldn't make you listen that long. I hope that her killer gets the maximum sentence.
I was always making sure she was okay and having a good night. And the last thing I told her was to call me in the morning and stay safe and that I love her so much. She said, "I love you too, sis," and hung up. Little did I know that that would be the very last time I would ever get to hear her voice. A 24-second phone call I never expected to be the last. On March 27th at 12:24 in the morning, my beloved sister was gone. This villain took my sister's life that night, but my sister's life was not the only thing it took. It robbed me of my happiness. It stole my smile. It took the best part of me I will never be able to get back. Because of this, my sister is gone forever, and every time I want to talk to Halia, I have to go sit at a graveyard and talk to her headstone, wishing I could just hear her voice one more time. I wish I could just wake up and run into her room and lay in her bed and hug her and tell her I love her just one more time.
The profound and devastating impact, with a heavy heart, with grief, and a soul burdened by an imaginable loss of my beloved firstborn daughter, who was taken from us in an intended act of violence. The pain of losing a child is indescribable. It's a constant ache in my heart, a knot in my stomach that never loosens. But despite my overwhelming grief, my role as a wife and a mother demanded that I become a rock for my family. From the moment that we received the devastating news, I found myself thrust into a whirlwind of emotions, shock, and so many new unknown responsibilities. Because in the wake of tragedy, a mother must A mother must summon the courage to face practical challenges that no parent should have to confront. Identifying and preparing your child's lifeless body, planning a funeral. Planning a funeral for our daughter felt so surreal. What will she wear? What casket? Flowers, music, where, headstone, obituary, transportations, accommodations. I'm sure I left a million things out. Trapped in a nightmare. I couldn't wake up. I can't wake up. No way to escape. Yet I had to stay strong.
Barozzini's family, struggling with their own sorrow, stood by her side throughout the trial. Barozzini spoke openly about how the incident had deeply impacted her life, stating, "There hasn't been a single day where this hasn't weighed heavily on my mind. I feel immense sympathy for the victim's family, knowing the pain I've caused them. At the same time, I feel for my own family, who have endured so much heartache because of this situation." During sentencing, Barozzini was handed a 3-year prison term, the maximum punishment for involuntary manslaughter. There is, however, a chance for her to be released early based on her conduct while in custody. In court, she apologized to the Culbertson family, saying, "I now fully understand and acknowledge the immense pain I've caused. This guilt will follow me for the rest of my life. I took a life, and I know that Halia's family will carry this pain forever, just as my own family will continue to suffer because of my actions." As Barozzini was taken into custody to serve her sentence, both families were left to confront the permanent consequences of that fateful confrontation. The community continues to mourn the loss of Halia Culbertson while wrestling with the challenges of justice, accountability, and the slow journey toward healing. On February 24, 2019, Abigail Lobish was placed in the overnight care of Dixie Denise Villa at an unlicensed daycare located on the Aliamanu Military Reservation in Hawaii. By the following day, Abigail was tragically found unresponsive. An autopsy later determined that Abigail had a deadly level of diphenhydramine in her system, 2,400 nanograms per milliliter, nearly double the known fatal concentration. Following her daughter's death, Abigail's mother, Anna Lobish, discovered that Villa had a history of operating unlicensed daycare facilities and had been the subject of numerous complaints from neighbors. Despite repeated shutdowns by military police, the daycare had continued to operate. Anna asserts she was unaware of these troubling allegations until it was too late. On November 6th, 2024, Dixie Denise Villa stood trial, facing a manslaughter charge in connection with Abigail's overdose death. Court records suggest that Villa allegedly administered the diphenhydramine to help Abigail rest after a long day. The next day, on November 7th, 2024, Anna Lobish took the stand, delivering a deeply emotional testimony about her daughter and her interactions with Villa. Her words painted a harrowing picture of loss and betrayal as the trial unfolded.
He said, "I have a 7-month-old in there, and a 2-year-old, and his face went white. And he said, "I'm sorry." He said, "I'm sorry your daughter didn't make it."
The defense attempted to question Anna Lobish's credibility by introducing information about her mental health.
Express your concern that they could test the breast milk that you donated, yes?
Yes.
And that they'll try to use it against you, correct?
Yes.
On November 12, 2024, the defense presented its only witness, forensic toxicology expert Okorie Okorocha. He criticized the state's toxicology findings, arguing that testing peripheral blood from the legs would have been more reliable. He also stated that the lack of testing on brain blood weakened the conclusion that diphenhydramine caused Abigail's death, suggesting the presence of the substance could be coincidental rather than the direct cause. On November 13, 2024, the state called Dr. Gates in rebuttal. Dr. Gates disputed Okorocha's claims, explaining that the toxicology lab had recommended testing a sample for further analysis. He also confirmed that the brain had been examined and tested, countering the defense's arguments.
What if there were more doses given? Could you say the same thing?
I cannot say that this was the only time in her life she was given diphenhydramine.
The prosecution argued that Villa intentionally gave Abigail a fatal dose of diphenhydramine. In contrast, the defense maintained that there was reasonable doubt regarding Villa's responsibility for the girl's death.
Ladies and gentlemen of the jury, good morning to you all, and thank you all very much
for your cooperation from the first day of this proceeding up to now. We understand the jury has reached a verdict, so will the foreperson please rise? Good morning, sir.
Good morning.
Has the jury reached a verdict?
Yes.
Have you signed and dated the verdict form?
Yes.
Can you please hand them over to Monty? You may have a seat, sir. Counsel, Ms. Villa, please stand. Madam Clerk, would you please read the verdict?
In 1 FFC 19-759, State of Hawaii versus Dixie Denise Villa. As to the charge of manslaughter, we, the jury, in this case, find the defendant, Dixie Denise Villa, guilty as charged of the offense of manslaughter. Special Interrogatory 1. If you find defendant Dixie Denise Villa, also known as Denise Villa, guilty of an offense, you must answer the following question. Did the prosecution prove beyond a reasonable doubt that the offense was committed against a child by a person that had legal or physical custody of that child? Your answer to this question must be unanimous. Yes.
Thank you. Ms. Cowell, any request to poll the jury? As to the matter of bail, prosecutors.
Your Honor, at this time, we are asking the court to increase bail and take the defendant into custody. The court in this case had previously reduced bail back in 2020. We are asking the court to impose $500,000 now that the jury has found the defendant guilty as charged of manslaughter. That was the initial bail set. We believe it's appropriate given the jury's verdict in this case. Further, would note that the defendant is currently pending misdemeanor theft charges in district court. Given that, we believe an increase in bail is appropriate.
Ms. Cowell.
Your Honor, we're just asking the court to allow Ms. Villa to remain on release status. She has remained arrest and conviction free. I understand there is a pending charge, but she is, of course, presumed innocent unless and until the government proves that she's guilty. She does request time to gather her things, end her lease, and mail her things to her mother in Florida.
All right. Now that the jury has returned with the guilty verdict based on everything else regarding this case, the court is granting the state's request to increase bail to $500,000. All right, you may have a seat, Ms. Villa. Counsel, all right, next thing here is sentencing schedule.
Your Honor, before we do that, we are moving for mistrial and asking for a new trial. Yesterday, the government gave us evidence that Anna Lobish lied on the stand regarding co-sleeping with her child. And we believe that this greatly affects the trial. In addition, this morning, I was texted information from a potential witness who says that she gave the Honolulu Police Department various documents showing that Anna Lobish needed to see a doctor for mental health reasons. That was never turned over to us. I heard of it the first time this morning at 6 a.m. via this text message. She sent me screenshots. I asked her to email me the information. We believe that given Anna Lobish's credibility, this greatly affects the trial, and so we're asking the court to declare a mistrial and grant a new trial.
Ms. Prosecutor.
Your Honor, this is appropriate for a motion for a new trial, which is now that we have taken the verdict and the defense can file its appropriate motion. We did turn over under our obligation the Hawaii Rules of Professional Conduct. The state does have more information to turn over. Our state was in the process of sending another letter over as well as redacted discovery before the court called for this verdict. So we will continue to comply with our obligations under Hawaii Rules of Professional Conduct, but this is right for a motion for new trial.
All right, Ms. Cowell, file a motion.
Will do.
Okay, all right. In the meantime, for now, sentencing schedule is going to be on February 26th, right? 26th, 2000, at 8:30. So, Ms. Villa, you are ordered to cooperate with the probation officer that will be in touch with you and prepare and present this report. And of course, the court will await filing of the motion for a new trial from your attorney, and then we'll schedule a hearing on that motion once the court is in receipt. All right, counsel, anything else?
Not from the defense.
Then we are adjourned.
After 7 hours and 39 minutes of deliberation spanning 3 days, the jury found Dixie Denise Villa guilty of manslaughter. Following the November 13, 2024 verdict, Villa's defense requested a mistrial, accusing Anna Lobish of providing false testimony. The defense cited newly obtained information about Anna's mental health as grounds to question her credibility. The judge instructed the defense to file a formal motion to pursue the matter further. Villa's sentencing is set for February 26, 2025. Meanwhile, Abigail's parents have filed a separate civil lawsuit against 10 defendants, including the United States government. The lawsuit alleges negligence, claiming authorities failed to adequately stop Villa from continuing to operate her unlicensed daycare despite prior complaints and repeated shutdowns by military police. Brandon Allen Janik's prior DUI conviction in 2016 played a crucial role in escalating charges against him in a subsequent case. In the 2016 incident, Janik lost control of his car, which rolled over multiple times, leaving him severely injured. As part of his conviction, Janik was warned about the potential consequences of driving under the influence, including the possibility of causing someone's death, a key factor under California law that allowed prosecutors to charge him with murder in a later case. On the morning of June 10, 2023, 47-year-old Joshua Gilliland, a longtime bartender at Cheers, was crossing the street in a marked crosswalk on his way to work. A car ran a red light, struck Gilliland, and fled the scene without offering assistance. 4 days later, Gilliland succumbed to his injuries, leaving his community and co-workers devastated by his loss. The San Diego Police Department launched an in-depth investigation into the hit and run. By September 2023, authorities arrested Brandon Janik after evidence pointed to his involvement. Investigators determined that Janik had been driving a rented BMW at the time of the crash. When questioned about the damage to the car, Janik reportedly told rental car staff that he had backed into something and heard a thump. At his preliminary hearing, investigators presented crucial evidence linking Janik to the fatal incident. Although he attempted to explain the car's damage, the evidence contradicted his account. Prosecutors charged Janik with multiple offenses, including murder, gross vehicular manslaughter, felony hit and run, and felony DUI.
What type of thing was that?
This was an auto accident, single vehicle auto accident.
And why was that claim assigned to the Special Investigations Unit?
So this one was referred to my team due to possible material misrepresentation of the facts of loss. There was also a temporary substitute vehicle, a loaner vehicle, if you will, that was also involved. So those were the main reasons they sent it to my team.
Generally, what do you do when you're assigned to a claim?
The first thing I do is review the entire claim file. That's all the notes that are in there, everything that's been done prior to me getting it, listening to all the phone calls that are in there, reviewing all photos, estimates, making sure I review every single piece of information. That's step one. Step two is formulating that plan of action that meets the standards of our claims department. That's typically where I start.
Can you briefly describe your plan of action?
So my plan of action usually entails one, running backgrounds on the parties involved. That's reviewing their prior claims history, how many accidents they've been involved in, their policy, is it enforced, is it not enforced, how many vehicles are on there. It involves completing a scene canvas, getting a recorded statement, basically getting as much information as possible and concluding it with getting a recorded statement, and sometimes we utilize an expert to render an opinion.
So in this case, you listened to that first notice of loss call, right?
Yes, I did.
And was that first notice of loss call completed on June 15th of 2023?
That is correct, yes.
Was it approximately made at 12:49 p.m.?
Correct, yes.
And what happened when that call came in?
So that call came in, and what was reported was a single vehicle accident. Mr. Janik called in reporting he was in a loaner BMW. His 08 BMW M3, if I'm not mistaken, was at the dealership, BMW dealership, getting worked on. And he reported he had gotten off work at approximately 10:45 p.m. the day prior, which is June 14th, 2023. And as he was reversing into his parking deck, his parking stall, if you will, the vehicle parked immediately on his left-hand side was a truck, was parked too close to the line, So as he's reversing, he accidentally dinged the door. The door made contact with the fence, the gate, if you will.
Was that first notice of loss call made with Brian Ship?
Correct, yes.
Your Honor, at this time I'm going to play People's Exhibit 70. I'd also ask it to be admitted with that stipulation number 10 for its foundation.
Any objection to the court's receiving People's Exhibit 70?
No objection, Your Honor.
Okay, People's 70 is received, so you may publish.
It is associated with People's Exhibit 70A, the transcript. So we'd ask that that be passed along to the jury right now.
Are you seeking to admit People's 78?
Yes, Your Honor.
Any objection?
Without objection, Your Honor.
70A is received, so that it may also be published.
I'm going to play that recording for you. I just ask you to listen to it with us together.
Please have transcripts back.
What happened?
It's the wrong transcript, Your Honor. Send it back.
Okay, counsel, you're responsible for the transcript.
After you did that first notice of loss call, what did you do next?
So I myself that was June 15th when the claim was reported. I myself was assigned to this claim on the 24th of June. That's when it first came to me for review. I believe I completed all of my backgrounds on the 3rd of July. And typically when I complete all my background initial searches and file review, I do reach out to the parties involved. So I did make that initial contact with Mr. Janik on July 3rd. And that conversation was simply letting him know that the claim was under review with my team now and that I'd be following up with him. I did request photos of the gate and fence that date, and they were received on July 6th, if I recall correctly, so 3 days later.
So you communicated initially with Mr. Janik via text message, is that right?
I believe, I usually do phone call, and if people don't answer, I also try text, so I might have tried both. I don't fully recall.
Okay, so you first called and left a voicemail for Mr. Janik?
Correct.
All right, and then after that, did he give you a call back?
I believe he called immediately back, if I recall, yes.
Okay, so turning to what's in front of you is People's Exhibit 71, do you recognize that?
Yes, I do.
What do you recognize it to be?
I believe this is the voicemail I left him.
And can you flip through that exhibit there on People's Exhibit 71? Does it appear to be fair and accurate as to your communications with Mr. Janik between July 3rd, 2023 and July 20th, 2023?
That is correct, yes.
The people seek to admit People's Exhibit 71.
Any objection?
No objection, Your Honor.
People's 71 is received.
And then people are requesting it be published to the jury.
Any objection?
None, Your Honor.
Is that the exhibit that was previously handed out?
No.
What number was previously handed out?
70.
No, I mean mistakenly.
I didn't see the one that was mistakenly handed out, Your Honor. It may have been 72A. Yes, it was 72A.
You may hand out 71A.
Can you explain generally just what you're saying in that voicemail?
So I'm basically letting him know that this claim was referred over to the Special Investigations Unit. There is an unlisted vehicle, meaning a vehicle not on his policy, that was involved. And per the file notes, it was regarding him backing into his parking deck. I let him know it was referred over to the SIU team, my team, and that I would be touching base with him, but I did want to see if he had any photos of any of the property damage involved, the fence, the vehicle, etc. I did let him know, obviously it was around 4th of July holiday, that I would be out on the 4th and I would return on the 5th. I requested a call back.
And after you left that voicemail, did you receive an immediate call back from Mr. Janik?
To my recollection, yes, I did.
And what, if anything, did he tell you?
From my recollection, he said he acknowledged that it was with my team. I did request photos. He said of the fence. He said he would provide those to me, and those were received a few days later. I did let him know I'd be following up for a recorded statement to schedule it, and he acknowledged that and understood.
So on July 5th, 2023, did you receive a text from Mr. Janik?
It was either the 5th or the 6th. I received photos of the fence, yes.
Okay. So turning to the following page of that text message. Is that top one from you?
Yes, correct.
And what did you say?
I received a text message from him and I acknowledged it, and I let him know that there was no photos received, and I asked him to please resend those photos.
And then shortly after, did Mr. Janik resend those photos?
Yes, he did.
And then what did you say next?
I just acknowledged that I received the photos and I thanked him.
All right, turning to People's Exhibit 82 and 83, which I believe are in front of you.
Okay, hold on one moment. I may have misspoken. So those are all People's Exhibit 71. There is no 71A, correct?
Correct.
Okay, so I misspoke. So those are all People's 71, which has been received. There is no 71A. We are going to need to break early for lunch. So before you move on to the next exhibit, we're going to break. We will come back at 1:30. Please make sure you leave your notebooks and your transcripts in your seat.
So, Mr. Garcia, when we left off, we were talking about those text messages between you and Mr. Janik. And you testified that you received 2 photos from Mr. Janik, is that right?
That is correct, yes.
And what were the 2 photos of?
Those 2 photos were of the alleged fence gate that the vehicle struck.
And you see People's Exhibit 82 and 83 in front of you.
Yes, I did.
Do you recognize those?
Yes, I did.
What do you recognize them to be?
These were the photos that I received via text message of the fence/gate that the vehicle struck.
And do those appear to be fair and accurate as the same photos that you received from Mr. Janik?
Yes, they are.
Your Honor, people seek to admit Exhibit 82 and 83.
Any objection?
No objection, Your Honor.
People's 82 and 83 are received.
May I publish to the jury?
You may.
Up on the screen is People's Exhibit 82. Is that one of the same photos that's in front of you?
Yes.
And next I'm showing you People's Exhibit 83. Is that the other photo?
Yes.
And what, if anything, did you notice about these photos?
The lack of damage to the fence or gate.
Now, prior to sending these text messages, you had listened to a first notice of loss call, right?
Yes.
And before I asked you if that call was at 12:49 p.m., but that was actually East Coast time, right?
Correct, yeah. All of our file notes are listed under Eastern Standard Time.
Okay. So was that call at 9:49 a.m. in West Coast time?
Correct, yes.
Okay. So I believe that People's Exhibits 70 and 70A have already been received, and I'm going to play that recording for the jury. This recording is about.
Please listen carefully.
This recording is about 14 minutes and 41 seconds long.
Janik's defense contended that there was no evidence proving he was under the influence of alcohol at the time of the crash. His attorney argued that Janik panicked after striking Joshua Gilliland and fled the scene out of fear and distress. Despite this claim, Janik's prior DUI conviction and his decision to leave the scene without rendering aid significantly influenced the case against him. Additionally, Janik faced an insurance fraud charge after investigators uncovered that he had filed a false claim for the damage to the rented BMW. This charge further further compounded his legal troubles, adding 8 years to his potential sentence.
In the Superior Court of the State of California, in and for the County of San Diego, Central Division, the people of the State of California plaintiff versus Brandon A. Janik defendant, case number SCD 300413. Verdict count 1, second-degree murder. We, the jury, in the above entitled cause, find the defendant, Brandon A. Janik, guilty of the crime of second-degree murder in violation of Penal Code Section 187A, as charged in count 1 of the information, dated November 7, 2024, signed by juror foreperson number 4.
In November 2024, a jury found Brandon Janik guilty on all charges, including murder, gross vehicular manslaughter, felony hit and run, felony DUI, and insurance fraud. The murder conviction was particularly consequential, carrying a possible sentence of 15 years to life in prison. Janik's sentencing is set for December 2024. The loss of Joshua Gilliland deeply affected the local community. Known for his kind nature and over 20 years of dedicated service at Cheers, he left behind a legacy cherished by patrons and colleagues alike. While Janik's conviction brought a measure of closure, the case highlighted the far-reaching and tragic consequences of impaired and reckless driving. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.